me from my winter hell. I've got candles and candy, I can be your daddy if you only let me creep into your prison cell. Hey baby, can you tell I'm not a criminal? Your choice is seminal. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true. Just speak low, stand in your row, try not to show this life's a show. Try not to glow way down below. Oh, it's a lot of woe, and that's not a place where you would like to go. I've got cigarettes and brandy, which could come in handy if you just help me loosen up my hand grenades fuse. Baby, don't refuse my truth, but it's up to you now to choose. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true, 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 true.
Well, hey, howdy, hi. What y'all doing? How's everybody doing tonight? It's good to see you guys. Hey, Cuffy. Hey, Irina. Hi, Leather and Lace. Good to see you guys. Welcome in, welcome in. All right. So today, while we were live about Karen Reed, and let me just say, I don't think that it was possible for me to heart Mr. Alessi anymore. But then today happened. And I just my love for him grew 2 sizes today. That was and we're not even done, but that was an amazing cross-examination. I mean, my goodness. He put it all out there. Hey, Sissy's mom, good to see you. Hey, Carol, good to see you too. Welcome in. All right. Now, while that was going on today, Linda Stermer was busy getting sentenced. Okay. Now, she was found guilty of, as you can see on the screen, y'all can read, beating him, setting him on fire, and then running him over with her van. Nothing that the defense put up moved those jurors. They found her guilty. Now, this is twice that she's been found guilty. This last time she had a retrial. And now we're going to get into her sentencing. So let me push play and see. Let me see. Want to get right to it. kind of trying to figure out what's going on here because, like, all of the sudden, people are at the
Check, 1, 2, 1,
podium.
2.
Ah, he's a checking it. I got confused. All right. Let's just go forward a little bit. All right, here's Linda being brought in. Oh dear. Well, just while we wait real quick here, let me just say some things. I see that Linda has been in jail awaiting her sentencing and has definitely not had a blowout since being incarcerated. Okay. Hold on. Let me just, I bet you it's right here. All right. There we go.
All right. Please be seated.
Hey, crocheting
The court
Bambi.
calls the case of People versus Linda Stermer, 0916654. Counsel, state your appearances for the record, please.
Susan Zachary for the people, Your Honor.
Morning, Your Honor, Jake Blair for the people. Morning, Your Honor, Wolf Mueller for the defendant.
Ron Skip Kelly for the defendant, Your Honor.
Thank you. And ma'am, you are Linda Stermer,
Yes, ma'am.
and you are here today with your attorneys. Have you had a full and complete opportunity to consult with them?
Yes, ma'am.
And are you prepared for your sentencing today?
Yes, ma'am.
Thank you. Counsel, there's no sentence guidelines in this matter due to the conviction offense, but any additions, corrections, or deletions requested in the PSI? Mr. Kelly?
Yes, Your Honor. We have noticed that there is on page 4 of the pre-sentence report, numerical number 2, that on the morning of January the 7th, a few hours prior to the fire, a residence, Linda Stermer, went to Marathon Station, 437 West Street, Joseph Street, Lawrence, and pumped gasoline in a plastic can. It is the testimony that is incorrect and that we would question and challenge that there is no evidence that gasoline was being pumped into a plastic can.
Thank you.
Objection.
Ms. Zeiderbean? or
Let me just stop you right there, sir. Objection. The gas attendant clerk did testify, and let me tell you what the gas attendant at Marathon testified to. She said that Linda Stermer pulled up to the pump. She said that Linda Stermer drove a Blazer, which opens, you can open the whole thing or you can just open the window. She opened the window. She put the nozzle of the hose from the pump in that window. That is not where the gas tank is located on that vehicle. I'm not even a car person, and even I know that. Yes, she did put that gas in a gas can. Now stop playing with people. Now you might interpret that as, you know, you're free to have your own interpretation of the testimony, but sir, that is what she testified to. Now you need to stop playing. Let the state speak. That was very rude. Here we go.
Mr. Blair?
Thank you, Your Honor. I agree. We talked about this a little bit. Chambers, I do think it's appropriate to amend it to say that the gasoline is being pumped into the hatch, the rear hatch of the vehicle. There was no testimony about the particular type of can that was seen at the Marathon Station.
Thank you. Ms. Cristianti,
Fantastic. So basically what we're getting at is there was no, okay, fine. The state has conceded. So there was no gas can back there. She just was straight pumping the gas into the back of her vehicle and it somehow didn't spill out. Okay. Okay.
thinking of this, counsel, let me know if this satisfies the concern. A few hours prior to the fire at her residence, Linda Stermer went to the Marathon Station, 437 West Street, West St. Joseph Street, Lawrence, period. Then this next sentence would say, a witness saw her pump pump gasoline into the back hatch of the vehicle, period. And then it would state Linda paid for the gasoline at the pump. Do you see that, Ms. Christianti?
Yes, Your Honor.
Does that work for the defense, those modifications and the prosecution?
Yes, Your Honor.
Okay. Mr. Kelly?
Yes, Your Honor, on page 8, under marriage, the name Chris Failing in reference to the relationship that should be removed from the report.
Any objection to removing the name Chris Failing and the information connected with it from the report?
Your Honor.
Ms. Christianti then will modify under the marriage grid, we'll delete the first block there indicating Chris Failing, former significant.
Neat. Are you talking about the little purple badges next to your names? Is that what you're talking about? Because that's YouTube. That's not Streamlabs, babe. That's a new thing. It wasn't there this morning. I don't have any idea what it is. It says it's something about XP, and at this point there's 50 XP. I have no idea what that even means. I guess if you guys look at your thing, it tells you guys what you have, but I have 50. I have no idea what this does. It seems like they're trying to do like some like weird hybrid of Twitch and maybe the Tickety Talks. Let me look into it. It's new. They just put this on and I have no idea what it does or how to use it. So after the live ends, I'll check it out and I'll let you guys know in the morning.
Significant other, 64 Coldwater, Michigan, sales manager, Michiana.
Yes, Your Honor.
Thank you. Anything else, Mr. Kelly?
Yeah, and just on the page 1 of the beginning of the pre-sentence investigation and the evaluation plan, they inadvertently forgot to identify the attorneys, all the attorneys in the representation of Mrs. Stermer.
Okay. Any objection to adding Mr. Kelly and Ms. Neeks to the PSI?
No objection.
So, Ms. Christianti, under evaluation and plan, it's the first paragraph. The last sentence states defendant has the benefit of retained attorney Wolfgang Mueller. If we could add Mr. Kelly and Ms. Neeks.
Your Honor, not for nothing, but Mueller is M-U-E-L-L-E-R.
M-U. And then change the spelling of Wolfgang's last name, M-U-E-L-E-R. Anything, any other requested changes? That's it?
Yes, sir.
Your Honor,
Yes,
Oh, I'm sorry.
the first and full name of the other attorneys listed, or just the last name?
sir. Ron Skipkelly.
Rena, R-E-N-A, Nix, N-Y-X.
Ms. Vasquez, please.
Let's get
Vasquez, right?
K-E-L-L-Y.
Okay. Thank you.
Good. Any
Anything else?
additions, corrections, or deletions sought by the prosecution?
No, Your Honor.
Okay. Do we have victims to speak, or victim representatives to speak? I think we'll do that at this time.
Yes, we have several, Your Honor.
Okay.
All right. Now, before the victims speak, I just want to remind everybody that they are victims. They're giving their impact statements. It's probably going to be difficult for us to hear, but I do think, that's the trigger warning. That's it. That's all. All right, here we go.
Maggie, is there Kleenex there, just in case? Yep. Okay, thank you. Good morning.
Good morning. I'm not sure I can get through this. I'm going to try. It's very short.
Take your time.
I love and miss Todd every day. He was a wonderful son, brother, and father to his 3 sons. It breaks my heart that he didn't live to see what wonderful young men and fathers his sons have become. He would have loved being a grandfather to his 6 grandchildren. Every time I see them, I see him smiling.
Oh, bless her heart. That is Todd Stermer's mom. For those of you guys who aren't familiar with this trial. Also, Megan Boswell's sentencing is on the 22nd. I'll be covering that as
Do you want
well.
to sit down, ma'am? Yeah, we can pull up a seat for you. Is that better? Do you want to try to finish what you were That's it? Okay. Thank you.
Todd was my brother, and I've been really conflicted about whether I wanted to speak today on his behalf or on all our family's behalf. Because nothing I say is really ever going to change. Todd's still going to be gone. Our lives are still never going to feel complete again. The hole of him not being here will never be filled. But not speaking or not sharing some of my outrage and pain over his death, not correcting the image that has been painted of Todd, doesn't seem right either. When Linda was let out of prison in 2018, our whole family was in shock. It was incomprehensible to us. These last 6 years that Linda has been out living her life shook my faith in the law and in justice and in all that is right. It's been so hard having to listen to her lies and having her play the victim in this. And every single time I hear her speak, I just think, who's checking that? Who knows? Who's paying attention to what is real and what is not real? Because she's lied so much that it's hard to keep straight. I think if anyone's learned anything at this point, is that Linda is incapable of telling the truth. So I'd like people to know that my brother, Todd, was not an awful person. He was definitely not the abusive control freak Linda and her lawyers tried to make him out to be. He was a good guy. He had a great sense of humor. He was kind and funny. He cared about his community and his family and his friends. He was always there if you needed him. They say if you want to know what a guy is really like, watch how he treats his mother. There wasn't anything Todd wouldn't do for Mom. He fully intended to build Mom a place on his property when she was older so he could take care of her. And I have no doubt that he would have done that. It was Todd who showed up with his truck on a Saturday when it was pouring rain to help me move. One of those washout pouring rain days, but it's just not going to let up. Had a whole house to move. Todd drove in from Lawrence. I was delighted to find out he was the only one there to help me move. And he just grinned and said, "I hope you're buying lunch." You could count on Todd. He was loyal and protective of those he loved. And he was gifted at making the ordinary fun. He was so creative and imaginative. He loved the holidays. He loved Halloween and Christmas. He made them all special for everyone. But just the everyday times that we spent with Todd were just as fun, just as great. Todd liked the classics. He liked Elvis Presley and Johnny Mathis and Randy Travis. He wasn't afraid to show emotions or cry, but he was one of the toughest people I knew. And it would have broke his heart to know that his death ended his son's childhoods and altered all our lives forever. One of the biggest heartbreaks for me to this day is that it's difficult to talk about Todd without talking about how he died. And there is no question that he suffered an excruciating and painful death. There wasn't one person who was there that day who didn't have a hard time talking about his injuries. I can't help but think about what Todd must have been feeling that day he died. What a Herculean effort it took for him to escape that house, to put out the fire engulfing his body, only to have her deliberately run over him with that van. And still he hung on. He was that tough. He was trying so hard to live. And it absolutely kills me to know that hers was probably the last face he saw in this world. Linda's an evil person. She deserves no one's mercy. She should never have been given another trial or let out of prison to start with. But now that she has been found guilty twice of this crime, I hope she will finally go to prison for the rest of her life, and we can be done with her. She doesn't deserve the hope of ever being free again. And while I'm normally a compassionate person, I have zero forgiveness in my heart for Linda. And I hope when death comes for her, I hope it is as painful and as agonizing as the one you put Todd through. You deserve it. You are an awful human being.
I just have a short statement from myself, and then I also have a statement from my sister Kathy, who cannot be here today, but asked me to read her statement. My statement's simple.
Okay, so this is Todd Stermer's brother. So for those of you guys who don't know what happened, in 2007, Linda Stermer set Todd, her husband, on fire. She poured gasoline on him, and he was caught on fire. He escaped the home. He ran out the front door. And when Linda saw him escape, she ran over him. Now, what she told people is that she didn't see him, that it was on accident that he was run over, and that the truth is they were hurting for money, and he probably started the fire himself to collect the insurance. That's what she told people. Then, and she was convicted. Then in 2010, her conviction was overturned based on the original trial, or her original trial attorney not getting any expert witnesses to testify about whether it was arson or not. And then also the prosecutor at the time made some remarks during his closing that the appellate courts felt were inappropriate, and therefore they granted her a new trial. And so she just went on, she had her retrial this year, and she was found guilty again.
This weekend, rest assured, we're going to be celebrating the holiday in Todd's memory. You'll be in prison. My sister Kathy's statement is such. The picture that she's referring to is on the right with her daughter. This picture was taken the last time I and my two children, then ages 4 and 2, saw my brother Todd alive. It was August of 2006. We were having a family dinner with Todd and his 3 boys and some other family members. We had a wonderful time. There was lots of laughter, silliness, which was usual when Todd was around. Todd was always a favorite with the kids, and my 2 kids adored their Uncle Todd. I think that this is because he had such joy of life and remained in touch with his inner child his whole life. I miss my brother. I think of him every day, and of all we lost when he was taken from our lives so brutally and so unnecessarily. My life and my children's lives are immensely poor for his loss, as are the lives of all his many friends and family members, but especially his 3 children, his boys. They lost their dad as teenagers and have had to go through the difficult years of early adulthood without him there to help guide them. They have grown into adults that I know their father would be proud of. I see Todd in each one of them, especially in their love and their prioritization for their children. We all lost so much when Todd was taken from us, but we have at least some memories of him to help us sustain us. I feel the worst and the sorriest for his grandchildren, who never knew, nor will they ever get to know, their grandfather, who would have adored them. Every time I am blessed with the chance to spend time with Todd's grandchildren, I can't help but feel sad that he never got a chance to meet them and to get to know him. I know he would have been a daily presence and a positive influence in their lives. Todd's death has left a giant hole in my heart and our family, but knowing that the person responsible for taking his life will spend the rest of her life in prison will help us find some peace and some level of closure. When you take into account all the people in whose lives have been made less by this untimely death, 2 life sentences don't seem enough. It's a beginning and it's a start, but it's not enough. For the past 6 years, we have had to live with the emotional and mental stress and pain that she was out of prison. She never should have been there. But knowing that Todd's killer is going behind bars for the rest of her life will provide us some closure at last. Thank you.
Thank you, sir.
Hang on, let me fix what I said. The crime happened in 2007. She went to trial the first time in 2010. She was released. Her conviction was overturned in 2018, and she's been out on bail since 2018. And her retrial happened in 2025, and now she's been found guilty again. Oh, wow. Crochet Lover says, today I happened to notice Ward case, well, it's case studies, but case files and Tanika's 2 cents opening. Oh, I'm going to have to go check that out. Cool. Thank you so much. All right, here we go.
Does that conclude the victim statements? Okay, thank you. Defense, anything you wish to say on behalf of your client before I impose a sentence?
Your Honor, I would like to say that no matter what I can say, no matter what's been said, the fact that this court has one duty only under the legislature, and that is to impose the sentence that's been mandated by the Michigan State Legislature. And my client, our client, is here to accept the court's imposition of that sentence, and we will move on from that point on.
Thank you. And Mr. Mueller, nothing?
I have nothing, Your Honor.
Okay.
Thank you.
Ms. Stermer, anything you wish to say?
Yes, Your Honor. I came to this court filled with hope. Hope that the questions which had been unanswered for so long would finally be answered. That this would finally be proven to all that the tragedy that took Todd from our lives was an accident and not a crime. Today, while I stand before you, innocent and wrongfully convicted, I am prepared for the battle ahead. My husband, my family, my daughters, friends, and legal team remain confident that this conviction will also be overturned.
Thank you. Ms. Seiderbean or Mr. Blair?
Thank you, Your Honor.
Excuse me, Miss Siderby. I'm not gonna. What? See how she is? Still Still. Oh my God. And yes, the daughter does still, her daughter still supports her. The children that she had with Todd do not, which are her sons. They don't support her. So that's interesting to me. Hey, Sprinkle Donut, listen, I hope you got it straightened out, babe. I don't know what's why it's not letting you join memberships, but I can't figure it out because like when I click the link, the membership link, it goes right to it does what it's supposed to do. So I don't know what's happening. The only thing I can think of maybe Sprinkle Donut is maybe you need to update your app. Maybe try logging out completely and then re-logging in. I don't know. But it's I want hey, not that Justin and Becky P. And did I miss anybody that has come in since we started? Brandy, hey. Hey, Seven Lilies. Hey, Rachel. Hey, the boss lady. What you doing? Yeah, she's over here, It's 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 everybody else's fault. This was an accident and all the things. Whatever. I don't know what the glitch in the matrix is, babe. And I gifted the last 5 of the memberships hoping that I would get you, and I didn't. I'm sorry. But maybe we can figure it out. I don't know I do not know. Can you even turn on your your membership gifts, like for you to be able to be gifted memberships? Is that even on? Sprinkled Donut? Here we go.
This family has waited years for their questions to also be answered. And the questions have been answered, Your Honor, by 2 different juries. We have had 24 people that have now said unanimously that Linda Stermer killed Todd. The questions are answered. I had the pleasure of getting to know this family over the last several years. And it was ups and downs, let me tell you, because they didn't understand. They didn't understand why she was out. They didn't understand why we were going to trial the second time. They didn't understand why these pictures couldn't be up at trial. And they didn't understand why they had to listen to all the defendants' lies about their loved one the entire trial. And then we couldn't say anything. We couldn't say anything. Todd was portrayed in very unfavorable terms through Linda's words. And I promised the family that today was about Todd. That's why these pictures are up here. It's to remember the Todd that is with his children, loving his children, smiling, loving his grandmother, loving his family. That's the Todd that I got to hear about for all of these years that could not be portrayed to this court. It could not be portrayed to the media. And so that's what today is about. It is a celebration of Todd. Now that 2 juries have found her guilty, Your Honor, we understand we're not arguing for any particular sentence, as we know what the sentence is all going to be. But we really just wanted to take this opportunity to be able to celebrate his life. His boys are remarkable. I've spent a lot of time with them. Their pain is deep. Their pain is deep. The wives that I got to meet of the boys are so supportive and loving and strong, but yet they're supporting of broken men who lost a mother and a father, and who are now then in this role of raising their own families, finding their own way in life, and raising their children without the help of their father. And the person they used to call Mom, now they call Linda. I just asked this court to remember in its elocution if it would also talk about Todd and the things that they heard today, because I think that's what the family would like. Thank you, Your Honor.
Thank you. Well, to the family members, first off, I do hope that you have the opportunity for closure, celebrate as much as you can celebrate something like this, but I hope that you do spend this weekend, as you talked about, honoring Todd. And again, hopefully today will bring you some level of closure. Ms. Stermer, you've now had the process that was due to you. You had an extraordinary team of attorneys working on your behalf, not for months, but for years. With ardor, they filed motions and pursued what appeared to be every avenue on your behalf. They brought in experts to undermine and contradict the testimony of the prosecution's experts and to bolster the defense theory of the case. You also had, this time around, a new prosecution team in this trial and in the years leading up to this trial. From this court's perspective, this prosecution was diligent, thorough, and zealous, but they also played by the rules and worked under the mantra of seeking justice, not just a conviction. All this to say that I'm confident, Ms. Stermer, that you received a fair trial. Murder is by its nature a monstrous deed, but the one you've committed is even more gruesome than most. You lit your husband on fire and burned him alive. When he made it out of the house and you had a chance to reconsider your actions, you instead doubled down and ran him over with your car. I cannot fathom the suffering he endured in his last moments of life. And I cannot fathom the damage you've inflicted on Todd's family, his mother, his siblings, now your grown children, his grown children. You lured them out of the house using one of your many labyrinths of lies. They went to the mall and movie at your request, thinking you'd be discussing divorce details with your victim. And you didn't even allow them to say their customary goodbye to their father before you murdered him. Now they live with not only the murder of their father at the hands of their mother, but the fact that had you not convinced them to leave, you may not have had your window, or at least on that date, to commit your heinous acts. Their testimony was clearly difficult, but it was compelling. Your sons displayed on the stand the courage and strength of character often associated with those who have endured significant trauma. I use the word sons loosely, as they clearly do not recognize you as their mother anymore. Suffice it to say that if there was ever a list of all of the things parents should do on behalf of their children, murdering the other parent would not be on that list. This court is to balance punishment, protection, deterrence, and rehabilitation where possible. I'm hopeful you will engage in programming when returned to the Department of Corrections, programming which may or may not provide some measure of rehabilitation, but only a sentence of life without the possibility of parole can protect others from you and deter others from committing like conduct. And only a sentence of life without the possibility of parole can properly punish you for the heinous acts you've committed in burning your husband alive and in leaving your children with that imprint forever. The sentence of the court is life without the possibility of parole. Credit is 3,367 days. I'm showing that financials have been, mandatory financials have already been paid, so I won't reorder those. And counsel, the judgment will this time state one first-degree murder conviction with the two alternative theories. Is that satisfactory to counsel?
Yes, Your Honor.
Peggy, select which one?
Well, I'll just put first degree and then put under two alternative theories, either felony murder or premeditated.
Thank you.
Does that work? Okay. Ms. Stermer, you have a right to appeal the conviction and sentence. You have a right to ask for a court-appointed attorney to assist you in that appeal if you're financially unable to afford your own. If you do wish to make the request, you need to fill out the paperwork we're getting you now and turn it back into the court within 42 days of today's date. Bond is canceled. Anything else, counsel?
Nothing further, Your Honor.
Definitely not.
No? Okay, here's her.
Nothing, Your Honor. Thank you.
Okay, thank you, everybody.
All I have to say to Linda is this.
No, you shut up! Don't talk to me! Don't talk to me, criminal!
That's it. That's all. She's right back exactly where she needs to be. She will have life without the possibility of parole. I feel awful for Todd Stermer's family. I feel horrible for his sons. I feel terrible that Todd will never get to know his grandchildren. And I can say that there isn't anything like being a grandparent. Now that I'm a granny, I get it. I get it. Um, when people told me, it's different when you're a grandparent, they were not lying, and they also told me that it's nothing that can be explained. You'll when you're a grandparent, you'll understand exactly. You'll remember this conversation. And yes, neat. They done took her headband and her bump it. That has been confiscated. No more bump it, no more headband, no more blowout. So yeah, I think it's awful. And his death was very torturous. It was heinous. It had to have been excruciatingly painful. And I don't know what her problem is. I don't even think that it's not like she did have a whole Sancho. Now, let me just say this. The boyfriend, the side piece, he didn't really want to claim her when he was up on the stand. He kind of made it like it was, NBD, and that she kind of chased him. And he was like, you're married. I don't know. But then continued to hook up with her and bang her anyways, whatever. He provided the only testimony that he really provided was nothing really of substance. But it didn't really pertain to the crime, because it's not like she murdered Todd to be with this guy. She straight murdered Todd because she just didn't want to be with Todd anymore. And I think Todd had found out about the affair. And I think that he was planning on divorcing her. And even though Wisconsin is a no-fault state, if you can prove adultery, it does make a difference in like alimony, stuff like that. So, it is what it is. And I think that's why she avoided it. And then to, turn around and blame him. And additionally, her attorneys, which they didn't, let me just be clear about this. It's people want to blame the attorneys, right? But attorneys are not allowed to lie. They can't make stuff up. Okay. So if they are asking questions, and they were, about Todd being jealous or being a control freak or being, abusive in some way, it's because their client told them that stuff. Okay. That's, that's where the join is, sprinkled donut, babe. Hold on. Let me just share my screen. Hold on a second. Give me a second, and I'll fix it. I'll show you guys. All right, hold on. Anyway, so her attorneys told, or she told her attorneys that. So it isn't as if they just made this up, and that's why that's why Todd's family was saying, like, bruh, what are you doing? Like, this came from her. That's why they said what they said, because it absolutely did come from her. Hold on a second. It absolutely did come from her. Let me see if I can scroll up here and find the membership link. Let me just drop it for myself. Give me a second. All right. Let's just we are going to help Neat Newt, we're going to help. Sprinkle Donut. All right, I'm going to share this tab instead. Let me skip this. Okay, here's where we're at. Here's the, can y'all see this? Yeah. Here's the Nightbot. So you click here. See how it pulls? It takes you to another screen. Do you have pop-ups blocked? Because that's what happens. It takes you to the home screen and then membership should pop up just like this. Can you see the link right now that I just dropped? Sprinkle Donut? Yes, exactly, Tara T. Just like Casey Anthony told Jose, it was her father and what her father supposedly did. Exactly. 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 That is so weird. Sprinkle Donut, is it possible? Did you accidentally maybe block me? Is that possible? Like, can you see any of my chats to you in the chat right now? We're going to straighten this out, you guys. I'm going to help Sprinkle Donut until we get this sorted. I'm at this point, I don't even, it's not about the membership for me. I am just, then you have, okay. So what I would think is that likely the problem is if it doesn't pop up, it's because you must have pop-up blockers blocked. Because if you're on your phone, it pops up for me on my phone too. Like if I go and click my phone right now, what happens is it'll ask open with Chrome, Google, or Safari. I'll click Safari because I haven't used that one in a while. And it goes right to it. So it's got to be on your end, babe. And I'm not exactly sure what's going on there, but, oh, that's right. She's in Michigan. My bad. Not Wisconsin. That's right. You guys don't have her. Okay. Sprinkle Donut. Can you see my A Dose of Jen Lu comments? Can you see them at all? Let me see something. Because 2 days ago, you were a member. You're right. I forgot that she was from Michigan. I'm sorry. You're right. Neat. My bad. You don't see the link when I post it. Okay. You somehow or another have me blocked, I think. Let me go over here. Let me stop sharing this one. Let me close this. Let me go to my studio. Let me just make sure that I don't have you blocked. I don't think that I do, because otherwise you wouldn't be able to chat. But let me go to the Dose of Jen Lu one and make sure that I don't somehow or another have you blocked. Can you not see it even when Neat Noodle drops it? Hold on. Let me see something. Let me see. Right here. Not this. Settings. Let me find it. I'm sorry, you guys. I want to make sure that we get this fixed. There's nobody blocked here. There's nobody blocked on my Dose of Jen Lu channel at all. See, I'm way too nosy. I would never, ever be able to be, you don't, okay, so let me say this, Sprinkled Donut, go check your settings. I think you have me blocked, babe. That is, you must have the ward case studies blocked. See if that's what it is. Or try to unsubscribe and then resubscribe. But also, hold on, I just saw this. I just saw Caroline. Here it is. Hey, Carolina, 12 months. Thank you so much for being here. It's weird because Sprinkled Donut, you were a member 3 days ago. Let me look at something. Let me go over here to let me go over here to the ward. All right. Let me do this. Let me do this. Give me just a second. Let me go right here. Hold on. Yeah, you're not blocked on here either. Mm-mm. Hang on a sec. Mm-mm. Nope. You're not on the blocked list. Yeah, so I think you must have me blocked or, yeah, we're all committed at this point. We are all committed at this point. We're going to help. This is our mission. This is our goal tonight. We are going to figure out exactly what the issue is here. And we are going to make sure that we can figure out what's going on with Sprinkled Donut. Also, okay, there's another thing that I can check too. Here we go. Let's see. Hold on a minute. Yeah, because you're definitely not blocked by me and you're not on my members list anymore. I don't know what you did, Sprinkled Donut. My goodness, babe. I do not know what you've done. Let's see. No. You haven't derailed anything. I was going to end it after the whole situation. It could have been like a pocket block, Sprinkled Donut. Listen, I have, when I ended the live today, okay, I was checking on my phone, okay? Because I always keep track of my chat on my phone just in case, right? All right. I had a pop-up when I opened up the app where I had the option to block Nightbot. I'm gonna come in and chat under the ward. All right, all right, sprinkled donut. And you see if you can see my comment. We're gonna fix it. We're gonna fix this. All right, here we go. All right. All right, here we go. I put it in the chat. I'll even highlight it as soon as it pops up. But yeah, I do not. Neat's been dropping it. The only thing that I can think of is that that she has blocked me, and if she has accidentally blocked me, she can still come in the channel and chat, because guess what? Most of the time, I don't chat under the ward case studies because it's not the one that has the premium. So hold on. Leave. So so I usually okay, so you can see that. Then that is as far as, okay, that's as far as I can go then. Okay. The only other thing that I can think of is go to your browser. Which browser are you using? Sprinkled Donut. When are you using Safari, or are you using Chrome? Because I don't know how to fix it on Safari because I don't ever use Safari. But on Chrome, just enable. Hold on, there's another way to type it in. Hold on, let me look at something really quickly. Let me just also, yeah. Let me just go over here really quick. There is a way to do it manually. Who just said that? So, okay, if you think you have me blocked, Sprinkled Donut, what you'll have to do is you'll have to close out of the chat. You'll have to get out of the live. You'll have to go to your settings. Let me see. I think you go to general. That's lies. Hold on. No. You have to go to your Google account, and go to people and sharing and blocked. I have no blocked users on this account. So, but there is a way to do it where you can just manually type it in. Give me just a second, because I remember what it is. Hold on. If you type youtube.com/channel/ the ward, the ward case studies /join, you should be able to do it. Yeah, try Chrome. Try doing it through Chrome. And you're right, Tara. The way that they do, it's because one's an Apple product, and one's a Google product, and they got beef, and it is what it is, and it is. Yeah, and you definitely have to go to your browser. Absolutely. All right. So, forgot what I was going to tell you guys. I think, let me see if I can put it in the chat, because I think this is how it's supposed to go. Hold on. Let me see. I think it goes like this. Not comma, Jen. Hold on. I think it goes like this. Stop it. Phone. My phone's acting up. I think this works too. Try it like that. There you go, sprinkled donut. That actually should work for you. I forgot what I was going to say. Who watched the last hour of Alessi's cross-examination? Let's see what happens. Yep, that'll work. That works too. See if that works for you, sprinkled donut. I might change it in the Nightbot then, if that works better. Oh my God, you guys, it was so good. It was so good. And he's not even done. He's not. I think he starts out tomorrow. Hold on, let me go back to I absolutely positively cannot believe that Brennan did not get ahead of that bullshittery. I don't know another word to use. Like, how are you being paid purportedly $500,000 and you did not go and check whether or not his curriculum vitae, his CV was correct? How did that happen? What do you mean? What do you mean? What are you talking about? $500,000. $500,000. It's Shannon, what's his last name? Hold on. Burgess. He is the digital forensic examiner. He examined the data from the Lexus, Karen Reed's car. I mean, he started, I cannot believe, I absolutely cannot believe that Brennan allowed that to happen. I absolutely cannot believe that that happened. Yeah, I'll put it on for us. Hang on. Let me see where I left off. I forget where I left off. Think about right here. Hold on. Ah, we'll go back just to about right here. Hold on, let me remember where we were at. Oh no, we were a little ahead of this. Or past the megabytes. Hold on a minute. Hold on. We'll just go back a little bit more and start from about right here. Whatever happens, happens. Whatever we see, we see. Here we go. All right.
Complete because the acquisition was only 8 megabytes in size, even though the chip has a storage capacity of 64 megabytes, correct?
Yes, that is correct.
And that's your October 10, 2024 report, correct?
Protocol.
I'm sorry, was it proposal or protocol?
Protocol.
Protocol?
It is a protocol.
We'll use protocol. And you blame this on the, quote, programmer's inability to fully read the component, close quote, correct?
Correct.
In point of fact, the manufacturing specifications establish that the total flash memory component of the chips in question is equal to 64 megabits, not 64 megabytes, correct?
That is correct.
64 megabits is 8 megabytes, correct?
That is correct.
That means the expansion chip was not incomplete, correct?
Correct.
The acquisition was the same data size as the total memory storage capacity of the chip, correct?
Correct.
Your protocol for data acquisition was based on a misunderstanding of megabits versus megabytes, correct?
It was based on a working theory and a misinterpretation, yes.
And that was your misinterpretation.
Yes, it was.
You mentioned Ms. Gaffney in your direct testimony. Do you recall that, sir?
Yes, I do.
She successfully acquired 8 megabytes of data from that expansion chip during the December 2023 chip-off, correct?
Yes, that's correct.
And that wasn't your only conversion mistake in your October 10, 2024 report, was it?
I'm not aware of any others.
You stated in your report that the data acquisition of the Micron JWB57 was incomplete because the acquisition was only 540 MB in size, but the storage capacity was 4 GB, and that's stated in your October 10, 2024 report, correct?
Protocol, yes,
Protocol.
correct.
The Micron JWB57 chip is 4 gigabits flash memory component, not a 4 gigabyte flash memory component, as you incorrectly stated in your protocol.
That is correct.
So contrary to your assertion in the report, 4 gigabits is equal to 50 megabytes, which suggests that all the available data was successfully retrieved from this chip during the first acquisition by Ms. Gaffney, correct?
Correct.
So Ms. Gaffney was not in error on that. She did not make a mistake on that, correct?
Not on that specific thing, yes.
Right. It was you that simply misunderstood the difference between gigabits and gigabytes, correct?
Misinterpreted, I would not say misunderstood.
You misinterpreted the difference between gigabits and gigabytes.
Correct. At that
You
time.
got
yes.
that wrong in layperson's terms.
Correct. I did make an error.
You stated in your report that micron, and I'm going to have to give an alphanumeric number because I know in digital forensics it's important to be precise and accurate, so bear with me, sir. You stated in your report that the micron 29F2G08 ABAEA is a 2 gigabyte chip, and that the acquisition should have been 2 gigabytes, but was incomplete because it was only 264 MB in size, correct?
That is correct.
And the micron, and I'm just going to refer back to the number to not repeat it, the long alphanumeric number, is a 2 gigabit flash memory component, not a 2 gigabyte flash memory component, as you incorrectly stated in your protocol, correct?
Yes, that is correct.
So 2 gigabytes is equal to 250 megabytes, correct?
Correct.
And that suggests that all available data was successfully retrieved during the first acquisition by Ms. Gaffney, correct?
From those chips, yes.
From those chips. Correct. I'm correct, right?
Yes.
Your opinion was again incorrect and was based on a misunderstanding of gigabits and gigabytes, correct?
A misinterpretation, correct.
A misinterpretation in layperson's terms. You got that wrong also.
It was an error, yes.
Did you have that protocol peer reviewed, sir?
No, I did not.
Was it peer reviewed by anybody at Aperture?
No, it was not.
Did you have a supervisor review that protocol before you filed it with the court?
No, sir.
You submitted your proposal based on your education, background, and experience, correct?
Correct.
Turns out that the entire foundation of your proposal was based on a fundamental misinterpretation of the difference between a computer bit and a computer byte, correct?
No, not the entire thing, no.
Well, certainly a part of it was, correct, sir?
Correct, partial.
You got conversions wrong with respect to analyzing 3 different chips, correct?
Correct.
And since you wrote that, have you learned the difference between a bit and a byte?
I've always known the difference between a bit and a byte, yes.
You learned that in this case from reading the affidavit of an expert for the defense who pointed out those errors before you submitted your supplemental report. Isn't that correct?
I would have to go back and look at the timing on that. I believe I submitted the supplemental before the protocol from the other expert.
Are you certain of that?
I'm not certain of that.
Isn't it the case that the expert for the defense submitted his affidavit before you submitted your supplemental report?
Objection.
Do you know that?
I do not know that.
You don't know one way or another.
Correct.
And that person that I've referred to for the defense is Matthew DeSogra. You know that name?
I do.
Okay, since this is the second time I have watched this, I understand this a whole lot better, okay? What this gentleman did is he proposed that there was still data from Karen Reed's vehicle that was not obtained in the initial acquisition, okay? And the reason he proposed that is because he, to use his words, he misinterpreted the difference between a bit and a byte. So all of that was actually already recovered. He didn't do anything, okay? Then on top, and then it's just going to get worse from here. Let me just not spoil it for you guys. Let me just let you watch. But let me speed it up just a little bit because I can't be up too late tonight because, you know, I got to be back live in the morning, and I'm already getting a panty and out of breath. Here we go.
And you have read Mr. DeSogra's affidavit in this case, have you not, sir?
I have, yes.
And you would agree that he pointed out these misinterpretations of yours in his affidavit, correct?
Correct.
I would like to go back to your January 30th, 2025 report. May I have a moment, Your Honor, please?
Yes.
Thank you. May I proceed, Your Honor?
Yes.
Thank you. In your January 30th, 2025 report, you know which one I'm referring to, sir?
Yes, I do.
Am I correct that you indicated that at the time of this, quote, incident, Burla did not offer support for the infotainment and telematics modules removed from the Lexus, but have since released updated software according to similar modules that are supported by in-vehicle acquisition?
That is correct.
And the infotainment module that was removed from Ms. Reed's Lexus is consistent with the MMU, you know what I'm referring to in the MMU?
Right.
It's consistent with the MMU documented by Burla and has been identified as containing an internal micro SD card not acquired during the initial chip-off acquisition by Mrs. Gaffney. You remember that statement in the report, sir?
I do, yes.
You obtained no additional information from the chips that were already analyzed by Ms. Gaffney, did you?
Correct.
Correct that you obtained no additional information, right?
No data of value from those chips, yes.
No data of value. So all the data of value Ms. Gaffney had already obtained from those chips, correct?
That's kind of a confusing question. So there was no data of value from those chips to begin with.
Fair enough.
Right.
So Ms. Gaffney didn't miss anything of value.
Correct.
Fair?
Correct.
She didn't miss anything
Do you
of
know
value.
how much the Commonwealth has paid Aperture to
Oh,
date
here we go.
for doing the work in this case?
I do not.
Do you have any involvement at all in knowing what the contract is between Aperture and the Commonwealth?
I do not.
Have you ever had any discussions with any colleagues from Aperture with regard to how much Aperture has been paid in this case?
No, I have not.
Do you have an estimation as to how much Aperture has been paid in this case?
Not off the top of my head, I do not.
You've never had any discussion with anybody at Aperture about the fees Aperture has charged the Commonwealth in this case?
No, I have not.
How much have you been
Who in
paid?
Aperture is in charge of knowing how much fees Aperture has charged the Commonwealth?
That would be the accounting department,
Would Dr. Judson Welcher know?
potentially.
Your analysis, I want to move on to another category, sir. Your analysis in this case was not strictly limited to data and science, was it?
No, it was strictly limited to data and science.
The Commonwealth requested that you review numerous materials in connection with your analysis in this case, correct?
I did review materials, yes.
You did not review the January 29, 2022 CARS report by, well, let me put it this way. Did you review the January 29, 2022 CARS report prepared by Trooper Paul?
No, I did not.
Do you know what a CARS report is?
I do not.
Do you know that a CARS report was prepared by Trooper Paul for this case?
No, I do not.
If there was a collision analysis and reconstruction report prepared by a trooper in that case, would you want to see a document such as that?
No, not for my analysis.
Would somebody at Aperture want to see that document?
Objection.
I'll reword. Are you familiar with collision analysis and reconstruction reports prepared by law enforcement agencies?
I am vaguely familiar, yes.
Vaguely familiar? Have you ever used one in your analysis at all?
I have seen them, yes.
You've seen them. And my question is, seeing them, have you ever read any of them?
Yes, I have read them. Yes.
Have you ever considered a collision analysis and reconstruction report as part of the work that you do at Aperture?
Not specifically a collision analysis report from law enforcement. We do routinely see crash reports, but I think what you're referring to is something else.
Are you aware of a supplemental collision analysis and reconstruction report of Trooper Paul of the Massachusetts State Police dated July 24, 2024?
No, I'm not.
Do you know whether Trooper Paul is part of the Massachusetts State Police reconstruction team?
I do not.
And lastly, do you know whether he's part of the reconstruction team in this case?
I do not.
Did anybody tell you to avoid reviewing a collision analysis and reconstruction report in this case?
No, they did not.
You did, however, review the 2024 testimony of Trooper Nicholas Garino in the proceeding of last year, didn't you?
I did for specific data, yes.
So that's not really science and data, is it? It's testimony.
Yes, it is testimony.
So you did review materials in this case beyond science and data, correct? You reviewed testimony.
Sure, that is common, yes.
Is it common? Hold on a minute. Back the milk truck up. Why would it be common? Why do you need to listen to Trooper Garino's testimony? You were in charge of analyzing the data that comes from the Lexus's infotainment system, the black box, as it were. What does Trooper Garino's testimony have to do with that? Not a damn thing. Let's keep moving.
Having reviewed Trooper Garino's testimony, you therefore are aware of the theory that he proposed in the first proceeding, correct? It was in his testimony?
Objection. I'll allow that.
I'm not. So specifically, I reviewed Trooper Garino's testimony for information related to the infotainment and telematics modules.
So did you read all of the testimony?
No, I would have skimmed it.
You would have skimmed the testimony?
Correct.
And how would you, and what would be the purpose to just skim it?
Sure. So I'm only interested in the information related to the infotainment and telematics modules.
So I want to make sure I have this right. So you would skim it, you would look for what you want to focus on, and as you sit here today, you don't have any recollection of what the theory of the Commonwealth was in the first proceeding?
Not from that testimony, no.
Do you recall Trooper Garino as part of what you reviewed? So you reviewed certain things of Trooper Garino in his testimony, correct?
Correct.
And in your direct testimony, you testified extensively about the iPhone of John O'Keefe, correct?
Correct.
And you looked at and testified about a lot of information from the phone of John O'Keefe. Is that a fair statement?
Location data.
Location
yes.
data. Did you read, therefore, Trooper Garino's claim that the last...
Objection. Objection. So why don't I see it sidebar and find out what's going on?
Sure.
Mr. Alessi. Sure, I'll come up there. No problem. Bev. Okay, I went and I looked up what this crown thing is. Okay, so how it works is this. You get XP by chatting and sending super chats and sending super stickers. It's a contest that goes on each live stream. So tomorrow morning when we start again, you all will be at 0. It's just a little thing that they do just for each live stream. I think the purple is a fantastic color. I'm a fan of the purple.
Mr. Alessi, is there anything we can go to and come back? If there's not, there's not.
It would be a bit incongruous, Your Honor, but I
Okay.
can do it if Your Honor would like.
Do we have any idea how much longer it's going to be?
I will go check.
Yes. Help your teammate out there.
I will show this to Mr. Brennan first, and then if the court would like to see it, we've got another.
That's, thank you.
Mr. Brennan.
Yes. Alessi, this is why I like Mr. Alessi. I'm going to stop right here because I don't want to interrupt him, but this is why I like Mr. Alessi. Mr. Alessi is what I like to refer to as the Judge Bev Whisperer, okay? He can pick up on her nonverbal cues as to when her cranky level is increasing, okay? And everybody knows that after lunch, Bev ain't got no time for nothing. She's in a rush. The crabby meter has gone, her crabby level has increased exponentially. She's short on patience, okay? But Mr. Alessi knows how to handle her. He knows exactly how to chill cranky Bev out and how to acquiesce to her in a way where it sort of seems like he handles her in a way, not acquiesces to her. Let me start again. He handles in a way where Judge Bev feels like he's acquiescing to her, but in reality, she's really doing the acquiescing. Okay. So she's giving in. And this is why I like him, because those are important details. Part of being a good attorney is you've got to be able to manage the judge. And Judge Bev she needs managing. Like, she's like super testy.
May I approach, Your Honor?
Yes.
Thank you. May I have this marked as the next exhibit for identification, please, Your Honor?
Yes.
No worries.
Easy, Friday.
May I, Your Honor?
Yes.
Thank you. Sir, I'm handing you what has been marked as Exhibit ZZ for identification. Ask you to take a moment to look at it, please. When you've had a fair opportunity to look at it, if you could pick your head up, sir, and I'll proceed at that time.
Okay.
So I'm going to just ask one predicate question and then ask you another question.
Sure.
Does Exhibit ZZ contain, and if you just answer this yes or no, that would be great. Does it contain location, data, information? Okay.
I'll allow that without pursuing
That's
it.
the only one I have for that purpose.
Okay.
Does it, sir?
Yes, it does.
Did you consider this part of Trooper Garino's testimony in any review that you've done in this case?
No, I did not.
Thank you, sir.
Yep.
On December, we're going to move on now to another topic, sir. On December 5th, 2024, Detective Lieutenant Brian Tully, you know that name, sir?
Yes, I do.
How do you know that name?
So he is the one who hand-delivered the infotainment and telematics module to our office in South Lake.
Exactly. So he delivered the infotainment module containing the SD card that you talked about on direct examination so that you could attempt to reinstall it in Miss Reed's vehicle for an in-vehicle acquisition attempt, correct?
That was part of it, yes.
That was part of it.
Correct.
That day you initially attempted an in-vehicle acquisition, meaning you reconnected the infotainment module to the faceplate in Miss Reed's vehicle and reinstalled both the infotainment and the telematics module for an in-vehicle unlock and acquisition, correct?
That was an attempt, yes, on December 7th, for clarification.
And that was on December 7th.
Correct.
And that was December 7th of 2024.
Correct.
You conducted this same testing on an exemplar vehicle. And to be clear, exemplar was a vehicle that Aperture had purchased.
Yes, that is a vehicle that Aperture has purchased.
So Aperture purchased it. And it's a vehicle, as I understand, you testified, that's similar to the vehicle of Miss Reed, correct?
Correct.
And so you call it an exemplar because it's similar to the vehicle in question, correct?
Correct. Correct.
So I'm going to continue using your parlance of exemplar vehicle.
Sure.
And so you conducted this same testing on the exemplar vehicle and successfully reinstalled and tested the infotainment and telematics systems for an in-vehicle unlock and acquisition, correct?
For an in-vehicle acquisition, not for an unlock.
Okay, so for just an in-vehicle acquisition.
Correct.
I appreciate the correction, sir. But in this case, with Ms. Reed's actual Lexus, you were unable to successfully reinstall and test the infotainment and telematics systems, correct?
Correct.
On Ms. Reed's Lexus, you were able to get the infotainment backlight and faceplate to illuminate, but in your own words, the infotainment system did not respond as expected, correct?
Correct.
So instead, you took the micro SD card itself and attempted to retrieve data from that card directly, correct?
Correct.
Lexus locks cards in its system, correct?
It does, yes.
If Lexus thought it was appropriate to access those cards, do you know whether or not they would have them unlocked? Do you know?
I do not know.
Now,
I'm
oh,
going
sorry.
to let the answers.
Thank you, Your Honor. I want to cover a basic question. Do you have any citation to any scientific literature where specifically what you did on this Lexus model has ever done before? Has it ever been done before, do you know?
No, not on this specific model, which is why we did the exemplar testing.
Right. So there's no scientific literature that states that the methodology that you used with this Lexus model is an appropriate methodology at all, correct?
There is literature that addresses the methodology in other ways, but not specific to this Lexus, correct?
There's no literature at all stating that the methodology that you used for this Lexus is the appropriate methodology to use for this Lexus model, correct?
There's no literature about this appropriate Lexus model, correct?
Let's talk about your initial report of January 30th of 2025. You issued your initial analysis and report on January 30th, 2025, correct?
Correct.
Your report included a general timeline analysis. You used that phrase, timeline analysis, that you stated could impact, quote, event reconstruction. Do I have that right? Your January 30th, 2025 report does not discuss a collision, does it?
No, not in my report, no.
As a matter of fact, your January 30th, 2025 report doesn't even use the word collision, does it?
Correct, because I'm looking at data from the infotainment and telematics module.
But the report of January 30th, 2025 does not even contain the word collision in it, correct?
I believe it does in the background portion, which would be on page 2 or 3, which would just be restating the, if you mind if I can look at my report?
Oh, please.
Sure. Go ahead.
No, so I apologize. The word that was used was incident.
Right.
Correct.
But you don't use the word collision at all in your January 30th, 2025 report.
That is correct.
I appreciate you checking that, sir. Also, and please keep your report handy,
Sure.
your January 30th, 2025 report does not in any way detail the timing of what you now call a text stream event at all, correct?
No, it does not.
So in your January 30th, 2025 report, you refer to It is an incident, and in your May 8th report, you refer to it as a tech stream event, correct?
That would be referring to two different things.
Right, but did you use the Parlance tech stream event at all in your January 30th, 2025 report?
No, I did not.
But you're using it now, correct?
Correct.
And we're talking about the same event, right?
Correct.
In fact, your analysis and conclusions were limited in your January 30th, 2025 report to generally identifying a clock skew between Mr. O'Keefe's phone and Miss Reed's infotainment system, correct?
That is correct.
On January 30th, 2025, you engaged in no further analysis to determine whether precisely the 1162.2 tech stream event that you now call it occurred, correct?
Correct.
Why not?
I was not asked to at that time. I was just asked to look at the general timeline and consistency of the timestamps.
So, back in January 30th, 2025, you were not asked to engage in analysis to determine when precisely the 1162.2 tech stream event occurred. Is that fair?
That is fair, and that is based on the common concept that, a lot of cases that we work, there is clock skew, but we do not have events to precisely determine what that clock skew is.
Understood. So, wasn't your goal, however, on January 30th, 2025, to determine the correct timeline of events relative to this incident? Wasn't that your goal?
It was my goal to determine the data from the infotainment and telematics modules that were missed in the initial download and create a timeline and consistency of those timestamps.
So, your goal was to create a timeline, correct?
Correct.
And that timeline, among other uses, was to be for your colleague, Dr. Judson Welcher, to use that in his analysis, correct?
That is correct.
So you knew not only what your purpose was, but you knew what your work was going to be used for by Dr. Welcher, your colleague, correct?
Well, I knew it was going to be provided, yes.
Well, you knew it was going to be provided. Have you ever talked to Judson Welcher, your colleague, about this case at all?
I have vaguely, yes.
How many times have you talked to him?
I would count a handful of times.
And just give me a general idea of the nature of the discussions between you and Dr. Welcher. You're both working on the same, quote, incident, right?
Sure, yes.
What would have been the nature of those discussions?
So those discussions would have been identifying what I found on the infotainment and telematics modules and discussing, explaining that data to Dr. Welcher.
So,
Hold on a minute.
did Dr. Welcher ever...
Hold on a minute. How can you explain any data if you misinterpreted part of the data to begin with? Who are you explaining anything to, sir? Who? Now you got me over here sounding like a dadgum bootleg Hogwarts owl. You can, if you misinterpret, how can you then explain? That would be like me getting up here and acting like I could pontificate and explain how the modern day combustible engine works for a car. I don't know anything about that crap. I couldn't explain how that works. Lord Jesus, fix it. Here we go.
tell you, your colleague, why he wanted to use that data for his purposes?
For reconstructing a timeline.
And for reconstructing a timeline and picking a time for the what you now call a tech stream event, correct? You knew that's what he was doing.
Correct, for a timeline, yes.
Right, so you knew that for the 1162.2 tech stream event, he was going to use your analysis back in January of 2025 to try to pinpoint that tech stream event 1162.2, correct?
That is correct.
You knew that.
Yes.
And you know that he used that data to select a specific range for that tech stream 1162.2 tech stream event, correct?
I don't know if select would be the right word. I understand what you're saying, yes.
What term would you use?
Sure, so based on the data, he's identifying the time approximately when that event would have occurred.
And that tech stream event, that 1162.2, is what Aperture is contending is a time of a collision. Is that correct, to your knowledge?
That's sustained on that. Ask it differently, Mr. Ness.
Do you know the purpose of the 1162.2 tech stream event in the analysis performed by your firm?
No, Dr. Welcher, I do not.
So you performed your analysis and all these timelines that you talked about on direct without knowing what Dr. Welcher was going to do with that data?
No, so sorry, I misspoke. So it would be to
Wait.
timeline the time and date, or to put a time and date with when that text stream trigger would have occurred.
Exactly.
Right.
Right. That's just exactly what he just said. You're getting butthead. That's it. I've had enough. I can't do it no more.
Okay.
I mean, when the Commonwealth decides to put people on the stand, is one of the criteria for making the cut to get on the stand to testify that if you're called out on your work, that you must get indignant and double down and then blame it on, I don't even know at this point, he's out here like Milli Vanilli, blame it on the rain. This is a mess. Oh my God, I can't with these people.
So you knew what the purpose was of your work with regard to Dr. Welcher's work.
Correct.
And isn't Dr. Welcher's work on the 1162.1 and the 1162.2 text stream event an important aspect of the work of Aperture in this case?
Yes, it is.
Did anybody from the Commonwealth ask you in your January 30th, 2020-25 report to not discuss your work in connection with the text stream 1162.1 and the 1162.2 events?
No.
But you didn't discuss that, meaning the 1162.1 and 1162.2 events, in your first report in January 30th, did you?
That was not part of my report, correct.
But you did delve into that, and pretty heavily, in your May 8th report, correct?
Correct.
And you delved into that pretty heavily in the middle of this trial, correct?
Correct.
So after the trial, do you know the trial started around April 22nd in this case? Generally?
Yes, generally.
If y'all thought that Mr. Alessi was mopping the floor with him before, y'all, it's going down. Meet me in the club. It's going down.
So let's do the timeline on this. January 30th, 2025, you prepare your initial report, correct?
Correct.
In that initial report, you mentioned nothing about text stream event 1162.1, correct?
Correct.
In that report, you mentioned nothing about text stream event 1162.2, correct?
Correct.
The trial starts April 22nd, correct?
Correct.
Roughly.
Generally.
No, the trial in this case, this trial, about April 22nd. After the trial starts, and after witnesses, of course, are appearing, you prepare another report, correct?
Correct.
And that's your May 8th report.
Correct.
Right in the middle of this trial.
Correct.
Let me just break this down for you. For no reason at all whatsoever, all of a sudden, he decides, you know what? I've done all this work, but I'm going to do another report, and I'm going to amend my report. Now, wait, he's about to get super indignant. Okay. This is not like when your girl over here has made an intro and plays it a few times on a live stream and realizes, there's some editing mistakes within like the first, I don't know, sometimes I can let it go for like 3 times, but by the 4th time, it's become a bother and I've got to fix it. This ain't that. Okay. This would be like me making an intro, using it, making a new intro, and then having another intro and going back to the first intro and re-editing it. That's what this fool's doing. Whoo-wee. This is too much. Yes, look at his eyes. This is an excellent pause. You better, Lord, fix it. He's over here like, Calgon, take me away. I don't blame you, bruh.
And right in the middle of this trial, you enlarge the number for the 21 to 29 range. That's bigger than what it was in your first report, correct?
No, that is not correct.
Well, you changed the number, don't you?
No, I did not change the number.
Well, let's go back to see exactly what you did, sir.
Sure.
Yes.
Let's start with
Let's
the basics.
check your work.
You said on direct examination, sir, that you prepared your May 8th report on your own initiative. Those were your words on your direct testimony, correct?
Correct.
I'm going to read the first line of your May 8th, 2025 report.
Okay.
Do you have it in front of you, sir?
I do, yes.
It starts, Dear Mr. Brennan. Do you see that?
Yes, I do.
Pursuant to your request. That's a request you're referring to of Mr. Brennan, correct?
Correct.
I have completed an additional analysis concerning the above referenced matter. To formulate opinions, the following additional items were reviewed. This wasn't done on your initiative. You put in writing you did it at the request of Mr. Brennan. Which is it?
So that was on my own initiative. This is a holdover, so a copy and paste from my original report.
Wait.
Yours? Explain.
Wait a minute. Back the milk truck all the way up. Back it up, put it in park, turn the ignition off, and place the keys on the seat and exit the vehicle, sir. Which is it, indeed? So now, Shannon with one N, you're copy pastaing. First of all, your CV is all the way wrong. It's all messed up. You either did graduate, you didn't graduate, you got a BS, you don't got a BS, you got a BS in, from a college that doesn't even offer a BS in that department. What in the actual F is going on? And now you're copy pasting emails. Are you for real right now? You cannot be serious. Hey, Michelle, good to see you, babe. This is what this fool is doing. And you want this jury over here to believe that your analysis on all this data from the infotainment system is correct because you were very careful and you dotted every I and you crossed every T. Meanwhile, you're copy pasting an email. Are you kidding me? So I'll take a moment.
Everything's perfectly all right now. We're fine. We're all fine here now. Thank you. How are you?
Jesus. Here we go.
Explaining the May 8th report.
So that was on my own initiative. This is a...
The Mr. Brennan, correct?
Hold on.
Correct.
It starts, Dear Mr. Brennan. Do you see that?
Yes, I do.
Pursuant to your request. That's the request you're referring to of Mr. Brennan, correct?
Correct.
I have completed an additional analysis concerning the above referenced matter. To formulate opinions, the following additional items were reviewed. This wasn't done on your initiative. You put in writing you did it at the request of Mr. Brennan. Which is it?
So that was on my own initiative. This is a holdover, so a copy and paste from my original report.
You're explaining the May 8th report in your language pursuant to your request as a cut and paste from a previous report?
Yes, I am.
Do you cut and paste important information from one report to the other without checking it for accuracy?
I copy and paste certain portions.
Do you ever review what you cut and paste to see if it's accurate?
Yes.
You didn't review it this time, though, did you, sir?
No, I did not think it was significant.
Oh, you don't think it's significant, sir, that the matter is in the middle of a trial and there's a request for a new report after testimonies occurred in that trial? You don't think that's important?
Objection. Sustained.
Why did you prepare the new report then?
Sure. So there was a claim from a PowerPoint presentation by Mr. DeSogra of trying to adjust clock syncs or making clock adjustments based on the synchronization of certain events. That was produced in March. Upon reviewing that, my initial thoughts were to address that in testimony. But as I was preparing for trial, I made the decision that it needed to be better addressed in a supplemental report.
But you understand that the report that you're referring to, that's the report of Mr. Soger, correct?
It is a presentation of Mr. DeSogra.
It's correct. A presentation. You understand his presentation merely was responding to the work that you did, correct?
No, that's not correct.
So your belief is that Mr. DeSoger's report didn't address at all what you had done?
Partially, yes, but no.
Okay, but let's cover the basics. You agree that Mr. DeSogra addressed, at least in part, the work that you had done?
He tried to address, yes.
Right. So do you know the date of Mr. DeSoger's report as March 5th? Does that sound right to you?
Yes, that's what I
So
said.
you had Mr. DeSogra's report that you claimed was the basis for you on your own in the middle of this trial, creating and submitting a new report. You claimed that the basis for that was Mr. DeSogra's report of March 5th of 2025.
That is correct.
You waited 2 months to do that?
Again, my initial thoughts were to address it on testimony.
My question, sir, is not your thoughts. Just, did you wait 2 months?
Just let him finish the answer.
Here's my question, sir, and finish it how you like.
Sure. So
2 months, was it 2 months between March 5th and when you submitted your report on May 8th? Was that 2 months?
yes, it is.
So, did you know when this trial was going to start, sir? Generally?
Yes.
Do you think it's fair to submit a report without anybody asking you in the middle of a trial?
No, it's not.
Sustained.
It's dirty pool.
As we've been discussing,
Thank you, Tara.
issued a brand new report, in this case dated May 8th, 2025, correct?
Correct.
That changed your analysis, correct?
No, it did not change my analysis.
Were there changes to your analysis in it?
There were clarifications.
Clarifications.
Correct.
We're about to argue semantics.
Address that. In your January 30th, 2025 report, you did not mention text stream event at all, did you?
No, I did not.
And you didn't mention collision at all, correct?
No, I did not.
And you mentioned both of those now in your May 8th, 2025 report, correct?
I don't know if I mentioned collision. I'd have to go to my report and look.
But you certainly do mention text stream events, correct?
Yes, that's
and
correct.
And you labeled them 1162.1 and 1162.2, correct?
Correct.
That's a change from your first report, isn't it, sir?
No, it's not a change. It's a supplement.
Oh, so your definition is that when you add something to a report, it's not a change, it's a supplement?
That is what it is, yes.
Who did you speak to regarding the May 8th, 2025 report before you prepared it?
And no one before I prepared it.
So you just prepared it on your own?
I did.
Did you have any communications at all? I asked you who you spoke with, but did you have any communications at all with either Detective Lieutenant Tully or Buchanan?
So I did reach out to Tully to get a full set of the location data, yes.
So you reached out to Detective Tully before you prepared your May 8th report?
Uh-oh.
Yes, that is correct.
Uh-oh. This is not good. This is not good. This is not good. It was me, Kristen. I got you. This is not good at all. Why did you reach out, sir? I thought this was... Bruh.
When the trial had started in this case?
No, not during that conversation, no.
That's not the first communication you had with Detective Tully, was it?
No, it's not.
How many conversations have you had with Detective Tully?
I would say a handful.
How much is a handful?
I would be speculating, but we'll say 5 to 10.
5 to 10?
Sure.
Is Detective Tully expert at all in digital forensics?
No.
But you've had 5 to 10 conversations with him?
Correct, to get provided information.
What information? Hold on.
At any time has
Excuse me, Mr. Alessi, I do not want to overtalk you. What information would you need from Trooper Tully, my guy? What would you need? The data is the data, right? You had the information. You had the infotainment system. What else did you need? That's what you were tasked with looking at. So why were you talking to him?
anybody from the Commonwealth had a discussion with you relative to your January 30th, 2025 report or your May 8th, 2025 report about keeping flexible the timelines for any events in this case?
No, sir.
Did you have any discussions at all regarding the May 8th, 2025 report you prepared in the middle of this trial with anyone from the district attorney's office?
Yes.
When did you have those discussions?
That would have been on, probably May 7th when I reached out to Mr. Brennan.
So you reached out to Mr. Brennan on May 7th, 2025, correct?
Correct.
That's before May 8th of 2025, correct?
Correct.
So before you sent that report in, you had a discussion with Mr. Brennan about it, am I correct?
Correct.
What was that discussion about?
That was just a discussion over the data and what the report said.
So you were discussing with Mr. Brennan what was going to be in your report, including data and analysis, correct?
Correct.
Did you tell Mr. Brennan that you were going to be submitting the report shortly to him on May 8th?
Yes.
Did you agree to a time when you would submit that report?
No, I did not.
Did you tell him when you were going to submit it?
No, I did not.
But after the conversation on May 7th, you discussed with him that you had either pretty close to finalize the report. It's a pretty extensive report, right?
Correct.
So on May 7th, you were pretty well along the way in that report, correct?
Correct.
Did you let Mr. Brennan know that?
Yes.
So he knew the nature of the report. He knew how far along you were with it.
Correct.
Did you have any other calls with anybody from the prosecution's office other than that about your May 8th report?
No, I don't believe so.
Did you have any texts with anybody about your May 8th report?
No.
Did you communicate with anybody else about your upcoming May 8th report?
No, I would have provided a copy to Dr. Welcher.
Your colleague?
Correct.
So Dr. Welcher knew you were working on this report, correct?
He knew I submitted the report. I don't know if he knew I was working on the report.
Did he know you were going to submit the report before you submitted it?
Yes, I'm sorry, yes.
Did he know what was going to be in the report?
Yes, he did.
Did he support the fact that you were going to submit a report in the middle of trial?
I can't speak for Dr. Welcher.
But he knew you were going to do it?
Correct.
Did he say anything, don't do that? Or did he have any comment about the fact you were going to submit it?
Not that I recall off the top of my head.
Not that you recall, so is it possible he did comment on whether you should submit it in the middle of trial?
No, he would not have commented on whether I should have submitted it or not.
How many times in your career, sir, have you submitted a supplemental or amended report in the middle of trial?
This would be the only one that I recall.
So this is the only time. How many years have you been doing this?
Approximately 10 years.
And so approximately 10 years, this is the first time you've submitted a amended supplemental report in the middle of a trial.
A supplemental report, correct.
As you call it, a supplemental report in the middle of trial.
Correct.
Do you know a person by the name of Ian Whiffen?
Yes, I'm familiar with the name.
You say you're familiar with the name. Are you more than familiar with his name? Are you familiar with his work?
I'm familiar with his report in this case, yes.
So you're familiar with his work if you're familiar with his report, correct?
Correct.
Oh, sweet Jesus. Let me just say what's going to happen, you guys, at the end of all of this buffoonery, okay? Currently, Brennan is sitting over there canceling, putting a stop payment on the check to Aperture. Aperture has pulled this guy's information completely off of their website. Then the Commonwealth is about to put a stop payment on Brennan's check. This is a huge mess. My God. My God.
Were you given do you know that Mr. Whiffen has testified in this trial?
No, I do not.
And with regard to Mr. Whiffen's report, did you read it?
Yes, I did read his report.
And that would be of interest to you, correct? That's why you read it?
Correct.
Because Mr. Whiffen's report, and are we talking about Mr. Whiffen's January 2025 report or his March 2025 report? Are you aware there's two of them?
No, I'm not.
Do you know which one you're referring to?
That would be the January report.
So the January 2025 report, are you aware that there's just a couple minor differences between the two reports, or you're just not aware of it?
I'm not aware of either way.
Assume there's very minor differences with the reports. Mr. Whiffin's reports contain information and some detailed, they're long reports, right?
Yes, they are.
So Mr. Whiffin's report contains information about the cell phone of Mr. O'Keefe, correct?
Correct.
It contains information about the location data in Mr. O'Keefe's phone, correct?
Correct.
It contains information about the phone calls in Mr. O'Keefe's report, correct?
Correct.
It contains information about the temperature of the battery in the iPhone of Mr. O'Keefe, right?
Correct.
It has some timelines in that report, correct?
Correct.
And those timelines have very specific events that are represented in the data from Mr. O'Keefe's cell phone, correct?
Correct.
As a matter of fact, it's got location data and times that you have used in your report and PowerPoint presentation here, correct?
Correct.
When did you receive the report of Mr. Whiffin with regard to the cell phone of Mr. O'Keefe?
So I would have received his report sometime in January.
So, 4 months ago, you had the report of Mr. Whiffin with substantial information about the types of databases you can find in the iPhone, location data, health data, phone calls, and a timeline, among other information, correct?
Correct.
You had all that information.
Correct.
And you had GPS location data in that report regarding Mr. O'Keefe's iPhone, correct?
Correct.
Do you know what an SQLite database is?
SQLite? Yes.
SQLite, yeah.
Yes.
And an SQLite database is one of the many databases that are contained within an iPhone, including Mr. O'Keefe's iPhone, correct?
Correct.
And you testified on your direct that you have general knowledge about cell phones, correct?
Correct.
And you say you've got certifications with regard to cell phones, correct?
Correct.
And your certifications include being able to read Celebrite and apply the Celebrite tool, correct?
Correct.
And you have certifications that allow you to apply and utilize magnet forensics, like, for example, their Axiom program, correct?
Correct.
And you've done that in your career. You've applied those tools before this case, correct?
Correct.
And you've applied those tools after your work in this case. You apply them pretty much frequently, correct?
Correct.
So the tools, the databases in an iPhone, and all the location data, etc., that was all information you had and you knew and had FASO with back in January of 2025, correct?
Correct.
And you had access to the SQLite database because you had Mr. Whiffin's report, correct?
Correct. I had the report, yes.
You had the report. Do you recall on your direct testimony saying that one of the reasons that you did this supplemental report on May 8th was you got new information or more information about Mr. O'Keefe's cell phone?
Yes, correct.
You had that information through Mr. Whiffin's report back in January of 2025, didn't you, sir?
Correct. I had the report. I did not have the data.
Well, didn't Mr. Whiffin's report discuss location in a pretty detailed manner?
Yes, it did.
And didn't he use GPS location data in that report?
Yes, he did.
What else did you need,
And
bro?
you had that in January 4 months ago, correct?
Correct.
And you read it 4 months ago.
Correct.
Yet you still submitted a report on May 8th in the middle of this trial, correct?
Correct.
Are you familiar with a digital forensic analyst named Jessica Hyde?
I am familiar with the
Oh,
name, yes.
God.
Do you know she's working on this case on behalf of the Commonwealth?
Yes, I think I have heard that in conversations.
All right, let me refresh everybody's memory about who Jessica Hyde is. Ready? Oh my God. Oh my God, this is a mess.
Have you read any of her reports?
No, I have not.
So you're aware she's working on the case, but you're not aware of whether she's issued reports in this case.
Correct.
So you're not aware whether she has issued reports that mention about GPS location data, correct?
Correct.
Did you ever ask for her reports?
No, I did not.
Did anybody ever tell you or comment to you whether your analysis is consistent or inconsistent with the reports of Mr. Whiffen or Ms. Hyde?
No.
Did you watch their testimony in this trial?
No, I did not.
Did you learn of their testimony in this trial?
No, I did not.
Did anyone from law enforcement or any other aspect of the Commonwealth provide you with any summary of their testimony?
No, they did not.
But you had access to Mr. Whiffen's report with regard to his analysis and the data from Mr. O'Keefe's cell phone back in January of 2025, correct?
Correct.
Having read Mr. Whiffen's January 2025 report.
I'm going to rewind that because I need for you guys to hear this sigh that Homeboy just did, because I feel like this sigh came from his soul. It was in this moment Shannon with one N knew he fucked up. Listen to this sigh. I don't know why I'd find that I need to hear this again or why y'all need to hear this again, but you do. Trust me. Here we go.
Mr. Whiffen's January 2025 report. You know that his report contains statements about movement and other activity of Mr. O'Keefe's phone after your time period in your original report of January 30th, 2025, correct?
No, not after the time period, no.
Let's take a look at that.
Sure.
Yes, let's take a look at that.
Let's take a look at your January 30th, 2025 report. Well, we'll come back to that. I'll do that in an order that makes a little bit more logical sense. You've mentioned, and just to cover the foundational parts, that you're not the only employee of Aperture that's been hired to testify as a witness on behalf of the Commonwealth in this trial, correct?
Correct.
Your colleague, Judson Welcher, Dr. Judson Welcher, has also been retained by the Commonwealth through Aperture, correct?
That is correct.
Justin Welcher, Dr. Welcher, is a biomechanical engineer, correct?
Correct.
Do you know whether Dr. Welcher holds any professional certifications?
I do not know.
Does Dr. Welcher's expertise extend beyond your own?
It is a different discipline than my own, yes.
So it's a different discipline. So it could be.
Hold on a minute. I would say the fact that he's being called a doctor would mean that his education extends beyond your own. You have not graduated, my guy.
Horizontally extended, and it also can be vertically extended depending upon the subject matter?
Sure.
That's a fair statement?
Sure.
Your colleague, Dr. Welcher, who is an engineer, did opine on the timing of the TechStream event 1162-2 in his report of January 30th, 2025, correct?
Objection. The objection is sustained.
I'll reword it, Your Honor. Do you know whether Dr. Welcher opined on the timing of TechStream event 1162-2 in his January 30th, 2025 report?
Yes.
So you do know.
Yes.
What is the timing of the TechStream event 1162-2 in the January 30th report of Dr. Welcher, your colleague?
Objection. So why don't I see you at sidebars?
Oh my God, Bev, you and your friggin' sidebars.
Slide discusses the 1160 report about
Correct.
food
Reviewed.
doing. May I proceed, Your Honor?
Yes.
Thank you.
Let me just say this. I would only rewind like this for Mr. Alessi. Mr. Alessi, if you're out there and you can hear this, I barely rewind for anybody, but for you, yeah, I'll rewind.
Thank you for your patience, Mr. Burgess. You're aware that Dr. Welcher created a PowerPoint presentation with regard to his work in January of 2025, correct?
Correct.
Did you ever discuss that work with Dr. Welcher that he was doing?
No, I did not.
Did you ever review any of his work at any point, including up to the point where you're sitting on the stand today?
I have reviewed the slides that are included in Mr. DeSogra's presentation.
Okay. In the slides that are included in Mr. DeSogra's report include, those slides you're referring to are the slides of Dr. Welcher, your colleague, correct?
Correct.
And the slides that are in Mr. DeSogra's report about Dr. Welcher that slide discusses the 1162-2 text stream event, correct?
Correct.
So you have looked at, albeit through Mr. DeSogra, you have looked at the slide that Dr. Welcher had in his report regarding the text stream event 1162-2, correct?
Correct.
May I approach, Your Honor?
Yes.
You're welcome. May I have this marked as the next exhibit for identification, Your Honor?
Yes.
Thank you. And court reporter.
AAA for identification. Okay.
Thank you. May I present it to the witness?
Yes.
Thank you. May I remain here for a few questions?
Sure.
Thank you, Your Honor. Mr. Burgess, if
Yes.
you could take a look at what has been marked for identification is AAA, and tell me, once you've had a fair opportunity to look at it, whether you recognize that slide.
Yes, I do recognize that slide.
And, sir, what do you recognize that slide as?
So it is a slide that states a number of times associated with text stream event 1162-2, which would be the second event.
And did you consider this exhibit AAA in your preparation of a response to Mr. DeSogra's March 5th, 2025 presentation?
Yes, I did.
I offer this into evidence, Your Honor, AAA for identification.
Okay.
I'd like to put the whole report in.
Your Honor, I have no need
Shut
to
up,
report
Brennan.
143 pages.
So I'm going to let this in, and I haven't decided yet about the whole 143 pages. Okay?
Fair enough, Your Honor. And I re-offer it into evidence, Your Honor.
Yes.
Be quiet, Brennan.
Could someone provide me with that 143 page today, please?
Hang on a minute, Brennan. Listen here. It's your report. Let's start there. And first of all, and you don't get to put anything in today. You're putting things in today is over and done with. And that's because you didn't even bother to check this guy out before he got up on the stand. This is poppycock, and you know it.
Sorry, what you asking for?
For a copy for me of that 143 pages before we leave today.
Before we leave, we'll get it, Your Honor.
Thank you.
One way or another. Thank you.
Yes.
You can, please.
Hold on, was it marked?
It's 188.
What number?
Bev, do try and keep up. It was marked as number 145. Jesus.
188.
188, excuse
May I
me.
present it back to the witness, Your Honor?
Yes.
Thank you.
And hold on. Also, Judge Bev, what do you need the whole 143 pages for? Bathroom material? Bathroom reading material? Is that what it's for? You ain't reading no 143 pages, Bev. You don't even like to go past 4 o'clock. If it's 3:55, you will stop court so that the jury can leave the courtroom and be out the door by 4 o'clock. Not the day is over at 4 o'clock and they get out to their vehicles about between 4:05 and 4:10. No. She wants these jurors off the premises by 4 o'clock. My God in heaven. And you expect us to believe you're going to read some 143 pages? Girl, bye.
Sir, you now have what is in evidence as Exhibit 188 for identification. I draw your attention, and this is the slide that you considered in responding to Mr. DeSogra, correct?
In response to Mr. DeSoger's analysis of this slide, yes, correct.
And this slide, to be clear, is a slide prepared by your colleague at Aperture, Dr. Judson Welcher, correct?
Yes, that is correct.
Sir, could you please read the time that Dr. Welcher states for the when infotainment trigger 1162.2 occurred?
So that would be text stream trigger, just for clarification, but yes, I can.
Well, let's go to that. You use the parlance text stream trigger. Dr. Welcher uses infotainment trigger, but it's 1162.2. You both use 1162.2, correct?
Correct, and I think that may be a misunderstanding of how he's worded it.
Well, Your Honor, I'd actually move to strike that about what Dr. Welcher. I'm just going to what the document says.
I'm just going to leave it, but go on.
Thank you, Your Honor. So the document says that the infotainment trigger 1162.2 occurred at approximately 12:31:38, correct?
Correct.
And that it ended at 12:31:43, correct?
Correct.
So we've got the trigger, according to Dr. Welcher, as of recently as January 30th, 2025, starting at 12:31:38 and ending at 12:31:43, correct?
Correct, according to the Lexus clock.
Right.
Yes.
So now let's go down to what says below. Per report from Ian Whiffen, O'Keefe's cell phone data showed, quote, most notably, all device lock events, including the final lock event at 12:32:09, were user-initiated by the user pressing the side button briefly. You see that, sir?
I do.
And did I read that correctly?
You did, with the caveat, that's according to the iPhone clock.
Right, but in any event, that's what Dr. Welcher states on his slide, correct?
Correct.
Do you know, sir, that the iPhone data reported by Mr. Whiffen that you read, that Dr. Welcher references, do you know that report of Ian Whiffen says there was an end of a health event of 36 steps covering a distance of 84 feet that ended at 12:32:16, which is after 12:31:43?
Yes.
And you know that?
Yes, with the caveat those clocks have not been adjusted.
But you know that there was a end of health event of 36 steps covering a distance of 84 feet that ended at 12:32:16, which is after 12:31:43, correct?
Correct.
Just stating the comparison. So now what I'd like to do is to move on with regard to the analysis. So, in Dr. Welcher wrote this. The slide he presented is dated January 30th of 2025, correct?
It's not dated here.
It's not dated.
But yes.
Do you know that Dr. Welcher created a report of January 30th, 2025?
I do know he created a report. Correct.
Right, and that's the same date as your report, correct? Your
Correct.
first report.
Correct.
So you both submitted your reports on the same date. They're both dated the same, at least, correct?
Yes, if they're both dated the same, yes.
Yes. Are you familiar
Hold on.
with the concept of...
Hold on. Shannon with one N, did you copy pasta the date on your report? Is that what you did? Bruh.
pocket state in iPhones?
I am familiar through Mr. Whiffen's report.
Okay. You said you've read Mr. Whiffen's report, correct?
Correct.
So you know that Mr. Whiffen states that there was a pocket state detected on the iPhone of Mr. O'Keefe at 12:33:14, correct?
Objection.
So the same, I'm going to strike it, do it the same way, Mr. Alessi, okay?
I will, Your Honor. Thank you. Are you aware of whether Mr. Whiffen has put in the report you read a timestamp for detecting pocket states of Mr. O'Keefe? Are you aware of that in the report at all?
I am aware of that in the report, yes.
Do you know when Mr. Whiffen has noted a pocket state detected of Mr. O'Keefe's phone? Do you know?
So, Mr. Alessi, why don't you show it?
That's what I was going to do. I will, Your Honor. And if we could put it, we've got it, that's already in evidence on the screen.
Okay.
It's already in evidence in screen.
So are you talking about Mr. Whiffen's report? Or
Correct. Well, you know what? I'm going to show him the report, Your Honor. I'll do it the way you suggest. Sir, do you recall the specific time that Mr. Whiffen has stated pocket states detected for the phone of Mr. O'Keefe?
No, I have not.
If I showed you a report of Mr. Whiffen, might that refresh your recollection as to when Mr. Whiffen has stated pocket state detective. Would that
Yeah,
help? the
yes,
record? Okay,
yeah.
sir, I'm going to endeavor to do that. If I can have a moment, Your Honor, I have it.
Yes.
Thank you.
Uh-oh, Judge Bev has both hands in her pocket and she's spinning in the chair. They're probably
I have
going
Your
to
Honor,
end
if
it
you have a
soon.
moment.
Hold on.
Got an agreement of sorts with Mr. Got an agreement of sorts with Mr. Brennan. Could I proceed, Your Honor?
Yes.
Thank you. Mr. Burgess.
Yes.
I'm going to show you what are 2 pages out of the report of Mr. Whiffen that you referenced, and we've been discussing about pocket state.
Sure.
And this one here, if you just read this line, because it's the heading, and then the next page, and tell me, sir, with reference to this entry right here, if that refreshes your recollection with regard to a column of pocket state with regard to the phone of Mr. and whether it refreshes your recollection on any comments Mr. Whiffen made about pocket state.
Objection.
I'm going to see it sidebar for 2 minutes on this. Okay.
Bev, stop playing with these people. You are not fucking seeing them at sidebar to talk about this. You're seeing them at sidebar because we all just watched you look at your watch, rock back and forth, sigh 3 times. You're ready to get the hell out of here.
Mr. Alessi, on this issue and
All right. Just let the jury go now. Let's see what she says.
Jury's left the room. Keep seated.
all right. So are we all set, Mr. Alessi, on this issue and for each time that might occur?
Understood, Your Honor.
Okay. All right. So we'll see you tomorrow.
Oh my God. All right, you guys. So that is all I have for you guys tonight. We're going to pick it right up there where we left off tomorrow morning at 7:55 Central, 8:55 Eastern Time, and super duper early if you're on Pacific. Okay. I don't even know what time that is on Pacific time. But anyway, thank you guys all for being here. I appreciate it very, very much. If you haven't done so, do me a favor, give your girl a thumbs up on the stream. I would appreciate it. And, crocheting Bammy. So, okay, I think what the sidebar was about, what had to do with basically refreshing the witness's recollection, but Alessi, in order to get this testimony in, respective to another person's report, he needs to lay the foundation that the witness is aware of the report first, then maybe aware of some specific points in the report before he can really start in on the testimony. It's, thank you, 7 Lilies. It'd be 6 a.m. Pacific Standard Time. Thank you. You guys are so helpful. Y'all are the best. But I would imagine that's what the sidebar is about. And I do think that she probably wanted him to at least offer to refresh the witness's recollection of a report that he looked at that didn't come from him. So anyway, that's all I got for you guys tonight. I'll see you bright and early in the morning. You guys have a great rest of your night, and I'll talk to y'all later. Bye.